or Code of Professional Conduct (CPC), which has been published by our Malaysian Medical Council, revised just last year. Uh, I think Prof. Datuk Mahmud has made my talk much easier by alluding to this document several times in his talk, and also he had actually elaborated on a few of the points. So, right. Before I begin with the actual text of the CPC, I would like to make you all aware that the Director General of our Ministry of Health is very concerned about the dissemination of this document, and that you all should be aware that such a document exists and you're aware of the contents of the document. He said the members of the medical profession are required to abide by the Code of Professional Conduct of the Malaysian Medical Council. That is the document that I'm going to elaborate to you in a while. And consonant with the motto of the council, which is safeguarding patients and guiding doctors, the objective of the code, the CPC, is to ensure propriety in professional practice by medical practitioners and prevention of abuse of professional privileges. So we hope that by making yourself familiar with this piece of document, you will be able to avoid a lot of difficulties in your career. And it will also mean much more safety for the patients that you're taking care of. There are three parts in the document. Part one talks about the powers of the Malaysian Medical Council. Part two explains in much elaboration on the forms of serious professional misconduct that any medical professional may, land themselves in, either by neglect or disregard of professional responsibilities, abuse of professional privileges and skills, conduct derogatory to the reputation of the medical profession, or by way of advertising, canvassing, and related professional offences. And part three covers the disciplinary procedures if by poor luck you happen to land yourself in such a circumstances. And by publishing this Code of Professional Conduct, it is the desire of the Malaysian Medical Council that no practitioner will have committed professional misconduct on grounds of ignorance of the expected standards of professional conduct in this country. So reading that document is actually a preventive measure against committing any of those misdeeds which are considered as wrongdoing in the medical profession. By powers of the council, what it means is that the council may exercise disciplinary jurisdiction over any registered person who has been convicted in Malaysia or elsewhere of any offence punishable with imprisonment, okay, whether in itself only or in addition to or in lieu of a fine. Secondly, has had his qualification withdrawn or cancelled by the awarding authority, which means that the university or the Royal College or whatever, okay, through which it was acquired or by which it was awarded. A person who was alleged to have committed serious professional misconduct as stipulated in the CPC, which I'm going to elaborate, the part in the part two of the CPC, that is the most the longest part of the CPC, and any other guidelines and directives issued by the council. There is a whole list of guidelines actually, which I'm going to tell you about at the end of my talk. And if the person has obtained registration by fraud or misrepresentation, that's also another category of people against whom the MMC has power to act against. Or if the person was not at the time of his registration entitled to be registered, that means he or she registered by fraud, or has since been removed from the register of medical practitioners maintained in any place outside Malaysia. So if you are removed from the register in Australia or in UK or wherever you practiced before coming back to Malaysia, that is also another thing which is where the MMC may exercise disciplinary jurisdiction against you. what is the meaning of serious professional misconduct? This is all about the what is in part 2 of the CPC. The Malaysian Medical Council attests to the principle that serious professional misconduct means a failure to meet the minimum standards of professional medical practice. Okay, as I'm going to inform you after this. Okay, right. First of all, convictions in a court of law. Okay, somebody who has been convicted in a court of law. Okay, the MMC can deregister you or take action against you, okay, because of that. All right. And please be informed that it is not open to a practitioner who has been convicted of an offence to argue during inquiry before the disciplinary board that he was in fact innocent. So this is to warn registered medical practitioners who face criminal charge that he or she should remember that if they are advised to plead guilty or not to appeal against a conviction merely to avoid publicity or a severe sentence, you should not, bend to that. Okay, you should defend yourself. All right. Right. The first part of the part 2 has got to do with a neglect or disregard of professional responsibilities. Okay. We must always remember that the responsibility for standards of medical care to patients is to provide and maintain a good standard of medical care. Okay, whether it is in the history taking, physical examination, investigation, management, whatever. Okay, so that is the first principle of a good medical practice that you must remember. This doesn't concern things which has got to do with errors in diagnosis or treatment, or with the kind of matters which give rise to action in the civil courts for negligence. That is a totally different thing. Okay, it's not included in this category unless the practitioner's conduct in the case has involved such a disregard of the standard of care that he should have provided to his patients, or such a neglect of his professional duties as to raise a question of serious professional misconduct. Okay, so just simple pure carelessness, which is unintentional and all that, that will be treated or brought to the court of law under civil suit. Okay, that's up to the patient to take up that kind of action. That is not for the Malaysian Medical Council to act against. Okay, what we are concerned about is the practitioner's conduct in terms of disregard of the standard of care that he should have provided to his patients. Secondly, the request of the patient for consultation with another practitioner. Okay, and a medical practitioner should arrange consultation with a colleague whenever the patient or the patient's next of kin desire it, provided the best interests of the patient are so served. So you must always entertain a patient's a request for second opinion with another colleague. In doing so, you should also acquaint your patient with the approximate expenses if the patient were to ask you. All right. And it is the duty of the referred practitioner, the one accepting the referral, to avoid any word or action which might affect the confidence of the patient in the primary practitioner, in the referring practitioner. Okay. And you should not say bad things about the referring practitioner, or this person doesn't know what he's doing, that kind of thing. That is wrong. Okay, that is bad conduct. All right. And the referred practitioner must not attempt to secure for himself the care of the patient seen for consultation. If somebody is referred to you, once you're finished the consultation with that patient, the patient should actually be sent back to the primary practitioner, unless there is reason for you to continue seeing the patient. Okay, and if you need to call other consultants in, it is better for you to get the primary practitioner to do that, okay? This is in 1.2.6 here. The referred practitioner is normally obliged when circumstances permit to consult the primary practitioner before other consultants are called in, okay? Unless the patient, prefers you to do the referral. And there is an ethical obligation on the practitioner not to damage the practice of a colleague or employer with whom he has been in professional association. Okay, for example, if you have been working with another practitioner before, you should not be setting up a practice close to the practitioner's previous clinic and procuring medical records of patients previously treated by you, inducing such patients to transfer to your new clinic, and so on and so forth. Okay, this is considered unethical. And in employing locums, you must make sure that the person that you employ is fully registered with the Medical Council and has a valid APC, Annual Practicing Certificate. So that responsibility is yours. Now, consent. I think consent has always been a very important legal document. Obtaining valid consent is an important component of a sound doctor-patient relationship. And for the consent to be valid, it should satisfy the requirements of what we call informed consent. It must be given freely and voluntarily by the patient, not induced by fraud or by deceit in what you say to the patient. It must be obtained in a language which the patient understands or with the help of an interpreter. Okay? And the patient or person giving the consent must have the legal capacity and soundness of mind and must be aware of the implications of undergoing the proposed procedure. And the procedure must be explained together with alternative procedures and the known complications. And the patient or person giving consent must be given sufficient opportunity to seek further explanations. Now, Datuk Mahmud touched on confidentiality as well just now. We must be aware that a registered medical practitioner is responsible for the confidential information obtained from a patient. Okay, the practitioner must ensure that the information is effectively protected against improper disclosure. And sometimes release of confidential information may be a statutory requirement. For example, you have to report certain infectious diseases and so on. You have to do that by law, but in the process, the patient must be informed of such a disclosure. Now, what do we mean by improper delegation of medical duties? This is in terms of employment of unqualified or unregistered persons. If you were to employ unqualified or unregistered persons in your practice, or get somebody to cover your practice who is not qualified and not registered with the Medical Council, and if you associate yourself with unqualified or unregistered persons, meaning that you get unqualified or unregistered persons to assist you in surgery or do some procedures under your supervision. However, there is an exception to that in terms of training and instruction of real, genuine, bona fide medical students, or the legitimate employment of midwives, medical assistants, nurses, dispensers, and skilled mechanical or technical assistants, and so on. Okay, so in training of medical students and trainees, that is considered acceptable, okay, but not otherwise. And you should not also indulge in partnership with unqualified or unregistered persons in your practice, in your professional practice. In terms of medical research, as we all very well know, it is very important to get ethical approval. And this paragraph is all about, the processes related to that. the consent, and so on. Okay. Now, in terms of pharmaceutical and medical equipment industry, there's a lot of catch here in terms of sponsorship, for example, and so on. So what you need to remember is a prescribing practitioner should not only choose but also be seen to be choosing the drug or appliance which, in his independent professional judgment and having due regard to affordability of the patient, should best serve the medical interests of his patient. Okay, you should avoid accepting any material inducement which might compromise or be regarded by others as likely to compromise your independent exercise of professional judgment in prescribing matters. Okay, therefore, it is improper for you to accept from a pharmaceutical firm, medical equipment industry, or other related services any monetary gifts or loans or expensive items of equipment for your personal use. However, if the payment made by such firm is for your professional work or consultation on contract by independent, then it is permitted. Or if it is donated specifically for purposes of research or for patient care. Okay. And this paragraph also goes on to say that, you are permitted to innovate, design instruments and so on, equipments for your practice, but they must be approved and registered with the Medical Devices Authority of the Ministry of Health. And you may receive appropriate travel grants and hospitality from pharmaceutical or medical instrument or equipment companies for conferences or educational meetings for purposes of educational and personal professional advancement, provided that such funding should not be more than what you may be spending if you were to go on at your own expenses. Right. In dealing with third-party administrators, you should also be careful. For example, insurance firm, managed care organizations, and so on. Okay, that you do not violate the code of professional conduct. Okay, in terms of interest, infringing on the interests of patients. Okay, so you got to be careful there. In terms of confidentiality and so on. Right. Traditional and complementary medicine, I think especially in general practice, private practice out there, this is becoming more and more of a point of contention. What is important is for you to remember that you should not prescribe or promote traditional health supplements or traditional medications or practice traditional treatment methods unless such products or practices are evidence-based. It always comes back to whether there's evidence to support it. Otherwise, do not practice it. And the practitioner should also avoid any conflict with the patient on professional fees charged by him after treatment or for any medical report, and should provide the patient with written information on estimated charges and the basis for them before treatment is commenced or report provided. This sometimes become quite an issue. Patients, after treatment suddenly land themselves up with a big bill, and at that point they get very upset and complain about the practitioner. So it is best to tell them beforehand what they're in for in terms of the medical in terms of the financial consequences. And with regard to expert testimony in court, sometimes, especially legal firms, they might ask for your expert testimony. You must make sure that such opinion, if you were to be asked for it, must be unbiased and honest, and bereft of any conflict of interest and confined to your area of expertise. Okay, and it is not ethical for you to demand a percentage of the cost or damages awarded by the court and to make the attendance fees contingent upon the favorable outcome of a matter in which you appear in court as an expert. Okay. Right. this has got to do with the end of life professional management. You must be aware that you must not be involved in euthanasia or assist in suicide of patients. Okay, and any decision to prolong life through life support or any other measures or to terminate such support must be made in your best professional judgment in consultation with your colleagues as well as the next of kin of the patient. And I think somebody asked about resuscitation of patient and so on just now. Now, if you are confronted with a living will, or what is called an advanced medical directive, which is a written statement detailing a person's desires regarding future medical treatment in circumstances in which that person is no longer able to express informed consent, then any decision that you make, whether to comply with or not to comply with the AMD that has been issued by the patient, must be made in consultation with relatives and next of kin of the patient. Okay, please remember that. Right. What about abuse of professional privileges and skills in terms of, this can happen in terms of prescribing of drugs, okay? So you must not abuse your privileges in terms of prescribing, especially not only just the regular drugs, but also particularly dangerous drugs, okay? And the sale of poisons, and in issuing certificates, notifications and reports, particularly medical sick certificates. This is quite often a case which is brought up, all right? The issuing of medical sick certificates without proper examination of patients, pre-signing of such certificates, failure to keep proper records in the patient's notes, backdating for unacceptable reasons, or issuing sick certificates for lengthy durations without interim examination, even for chronic illnesses, is serious professional misconduct. Okay, please bear that in mind. And with regard to medical reports, a medical practitioner may be required to provide comprehensive medical reports when requested by patients or by legal next of kin in the case of minors or persons under disability, or by the employer with the specific consent by the patient. And any refusal or undue or unexplained delay in providing such a report or withholding of such report on the grounds of non-payment of hospital charges or professional fees is deemed unethical. Okay. And a practitioner must not enter into an emotional or sexual relationship or any act which may be interpreted as sexual harassment with a patient or with a member of a patient's family, which disrupts that patient's family life or otherwise damages or causes distress to the patient or his or her family. Okay. And in the same category of abuse of privileges are abuse of trust, abuse of confidence, or usage of undue influence, like for example, using your influence on the patient to borrow money from the patient or something like that. Okay. And if you are unable to perform your professional duties to your best level because of some kind of illness or disability, and you have an ethical obligation to inform your senior colleague about your problems, and you may voluntarily cease practicing. Okay. And with regard to medical errors and incident reporting, a medical practitioner who commits errors in the course of management of his patient must avoid concealing them from the patient or those in authority, and must record such events in the patient's records or notes. It is unethical for the practitioner not to be truthful and honest in such an event. With regard to chaperone, a request by a patient for you not to have a chaperone present must be documented in the medical record or notes and signed by the patient, particularly if it is a different gender. All right. And The practitioner should, in those circumstances, request the chaperone to be in an adjoining area in case assistance is needed. And this is about, torture of human beings and all that, okay? Respect for human life. All right, the practitioner must not countenance, condone, or participate in the practice of torture or other forms of cruel, inhuman, or degrading procedures, whatever the offense of which the victim of such procedures is suspected, accused, or guilty of. Okay. And whatever the victim's beliefs or motives, and in all situations, including armed conflict and civil strife. Right. Personal behavior. Datuk Mahmud touched on this as well. It's important to remember that the public reputation of the medical profession requires that every member of the profession should observe proper standards of personal behavior, not only in his professional activities, but at all times. This is the reason why the conviction of a practitioner for a criminal offense may lead to disciplinary proceedings, even if the offense is not directly connected with the practitioner's profession. Okay. And this has got to do with, things like abuse of alcohol, abuse of drugs, dishonesty in financial transactions, okay, fee splitting, kickback arrangement, that is a no-no, okay, acts of indecency and acts of violence, all that are covered under this. It can land you in with disciplinary action from MMC. Right, if you know that a colleague is incompetent to practice, say for example, he's taking drugs or having any physical or mental incapacity, then you should advise the colleague to report himself, or if he or she does not want to report himself or herself, then it is your responsibility to report that colleague, okay? Particularly if you are taking care of that colleague medically. Right, this is about commercial undertakings. The association of a practitioner with any commercial enterprise engaged in the manufacture or sale of any substance which is claimed to be of value in the prevention or treatment of disease but is unproven or of an undisclosed nature or composition will be considered as serious professional misconduct. So be aware. Okay, and plagiarism is also considered something which against which the MMC can take disciplinary action against you. Okay, there's a whole lot of paragraphs on advertising and canvassing, but in short, what it tries to say is that you should not be advertising your practice in order to get financial gain. Okay. All right. So in disseminating information about your practice, you've got to be careful, okay? Because if it is improper and against the rules laid out in the Code of Professional Conduct, then action can be taken against you. Okay. A practitioner may carry calling cards, but he should not distribute calling cards with the purpose of soliciting patients. Okay. So in other words, you should not be deliberately trying to entice patients into your practice. Right, the disciplinary procedures in MMC, okay, just to let you know, okay, there is a disciplinary panel which is set up by the Malaysian Medical Council, and the members are appointed by the council from among council members or from among fully registered medical practitioners who have at least 10 years of good standing with current APCs, or any other person other than council members and fully registered medical practitioners with 10 years of good standing, or the members of the disciplinary panel and the members of the disciplinary panel shall hold office for a term not exceeding 3 years and may be eligible for reappointment. And the council may at any time revoke the appointment of any member of the disciplinary panel. So the membership of the disciplinary panel may be from among council members or any other practitioners which fulfill the requirements, or any other persons. Sometimes they are non-medical professionals. And there are two different sort of like committee or boards. Okay, one is the preliminary investigation committee. Okay, this is the committee that is set up to start investigating into whatever complaint that is lodged with the MMC by anyone. Okay, and from there, if the PIC thinks there is a case to be brought up, then the case would then be forwarded to the disciplinary board via the council meeting. Okay. And these are the guidelines and related publications that you can find in the MMC website. So be familiar with them, especially if they are within, you know, your area of expertise. So in summary, the Code of Professional Conduct details the do's and don'ts that the registered medical professional must abide by. And also the disciplinary procedure, which goes on under the Malaysian Medical Council. And all medical professionals must familiarize themselves with the CPC so that you can maintain patient safety and you know your professional rights and privileges, and thereby preventing any disciplinary action against you. And you should also know MMC disciplinary procedures just in case you had the bad luck of having to, you know, have any complaints lodged against you. Okay, and the Code of Professional Conduct is downloadable from the MMC website.